fast forward in come watch on so AGH Politics Avenue. Political stories are training because making headlines na jembre na di Akroma ewo ha ni di mo raksimo onua yenko yingsimo Miracle Aboaje na watchre say Chief Justice the removal no there's a problem with it or just say the basis for Tekunu's removal problematic. Miracle Aboaje edi entina ma abranti kasa waje ya jemre ewo ha sia ono wankasa etunu no mutu yemungram ni hwe ne yeko ene de ba AGH Politics Avenue am sure say wajemre ewo
to write a petition against a woman and take it to the president. Okay. Then the president will refer it to the Chief Justice. Then the Chief Justice say, Madam, you know you are no longer the Chief Justice. But people are saying you can no longer be a judge. According to the Constitution, 1464, come and defend yourself. Please. Then the Chief Justice will form a committee.
So the new Chief Justice?
Yes. Okay. Because that is the only way you can remove a judge of the Supreme Court. Please. You cannot use 6 to remove
so that at her time, there should be a petition sent to her to make a prima facie on herself.
No. The Chief Justice has now been removed. That is established. He's now been removed.
Okay.
That's why I'm saying that he's been removed as the Chief Justice.
Hold on. Don't worry. Allow him.
He's been removed as a Chief Justice, which was a function.
Okay.
Remember, it was a function.
The last question I'm going to ask you, let me put it to Theo Champong. Dr. Theo Champong.
I thought you
hold on. Dr. Theo Champong. I don't know if you share Dennis's view, but even if you don't, what do you make of the Supreme Court in at least 3 different decisions, even though those pronouncements are not what we call the star decisis that decides the case? You see that prima facie for a Chief Justice is actually not in the Constitution. It is the Supreme Court that made a decision and said the same way that if you are removing any judge or a judge of the Superior Court, you get the CJ to make a prima facie. If you want to remove the Chief Justice, you must also do a prima facie. It's not in the Constitution. The Supreme Court said it, and now it has become part of our law. This same Supreme Court, on 3 different occasions, has made pronouncements which we can say are not law. But they say that if a Chief Justice is removed, they are equally removed as a Justice of the Superior Court. Do you think it's as straight as this one?
Yeah, so fundamentally, the point that I have been asking myself, right, is does the Constitution treat the Chief Justice and then the Justice of the Supreme Court as distinct constitutional roles with separate sort of appointment rules? And if that were the case, then in other words, does the removal of a Chief Justice then automatically also remove her as a justice of the Supreme Court? Because that's the core and the argument that Justice Tokono really right is making. And my view, or sort of what she's arguing, right, is that these are very 2 distinct roles. And when you look at the constitutional provisions that others have cited, the processes for the removal are slightly different, but the grounds for removal is pretty much the same. So in my view, the starting point is 1461, right? And the 1461, which you read, which I luckily have my old copy here as well, says that a justice of the Superior Court or a chairman of a regional tribunal shall not be removed from office except on those 3 grounds which you read: stated misbehavior, incompetence, or grounds of inability to perform due to infirmity of body or mind. Then the 1462 all the way to 1466 really gives the process for the removal. So for me, the point that I argue my position on is the first 1461, the beginning point, a justice of the Superior Court. Is the Chief Justice a justice of the Superior Court? Yes. Was she removed on any of these 3 grounds: stated misbehavior, incompetence, or inability to perform? And we know that per the report that was issued, she has been removed on the grounds of stated misbehavior. And it's quite clear I'm no lawyer, but just reading this and applying sort of logic to all of this, once she has been removed as the Chief Justice, automatically she loses her position as a Justice of the Supreme Court on the grounds of the stated behavior or incompetence or any of the other things that have been mentioned. So I don't want to beat about the bush. The starting point, which is very clear to me, is 1461. The 1462 and all the other processes around that to sit is really in terms of the process by which you go about doing that removal. And if she has been removed on the basis of stated misbehavior, and it says in the 1461, a justice of the Superior Court, then I struggle to see personally, how we could sort of argue that the two are distinct roles. But again, she has the right to go to court. And this going to court or even taking it up in other sort of separate legal processes can only help improve our jurisprudence, right? We are debating this. If she goes and the court rules in a separate way, that becomes a settled law. But as far as I have read this constitution, especially on the 1461 and the grounds for removal, that clearly says that a justice of the Superior Court, and the Chief Justice is a justice of the Superior Court. In this case here, it's a bit of a, for me, moot point to sort of argue that the two are slightly distinct, and therefore she cannot be removed. Once she's been removed as a justice, as a Chief Justice, then she should still stay as a justice of the Supreme Court. I mean, even put the legalities aside, but in terms of even the optics, right? How do you then still go back to the court, engage with your other colleagues and all of that? It doesn't really kind of come across right.
Thank you very much. Do you still want to say something? Hold on. Please hold on. So as Roxanne referred to the three cases, in 1996, in the Justice Saban case, Justice Pega said that the removal of the Chief Justice as a fallout, a judge of the Supreme Court, the substratum of the plaintiff case was that as we have stated earlier, is that the second defendant is not a man of high moral character and proving integrity to be the Chief Justice. Ipso facto, a judge of the Supreme Court, since the qualifications are admittedly the same, if the second defendant is disqualified from occupying the post of Chief Justice on grounds of lack of integrity, I do not see how he can continue to be a judge of the Supreme Court. And then in 2006, 2005, Modibo Okran in that other case says, with no such gap filling, one is left only with Article 146, Clause 1. And since the removal of the Chief Justice of Ghana from office is pegged to the same set of grounds as any other Superior Court judge, the Chief Justice, upon removal, will by implication also lose his position as a judge, unfortunate as it may be.
Yes, Sam, this matter actually came up in the Ajechum case. There was an issue. And the court determined that issue. So here's what Justice Dateban said. Are the administrative acts of the Chief Justice immune from the impeachment process? The next declaration, so I want to read. I won't say anything. I just want to read what he wrote quickly.
Yeah.
The next declaration whose grant or refusal I will consider is the first one sought by the plaintiff. It will be recalled that the declaration sought is in the following terms. A declaration that the petition dated 13th January 2006 presented by Mr. Brian Akote to the President, which relates to the removal of the Chief Justice, is in respect of the performance of administrative functions of the SC.J within the meaning of Article 1254 of the Constitution, and is therefore inconsistent with the said article. Then he went on, but this is where he exploded. He exploded this way. He said, I think that the plaintiffs, or let me give this argument. Further in paragraph 8, he sums out the essence of his argument as follows. The exercise of administrative powers by the Chief Justice, such as the transfer of enforcement of discipline among judges enjoys complete autonomy and freedom from interference by the executive and parliament. The effect of the president's appointment of Committee 2 in essence question or inquire into the exercise of those administrative powers by the Chief Justice is to violate clear constitutional dictates and can properly be regarded as a breach of Article 1271 and 2. It undermines the authority conferred on the Chief Justice by Article 1254 as Chief Executive of the Judiciary responsible for administration and supervision of the Judiciary. Surely, transfers and dismissals of judges by the Chief Justice cannot be considered acts of misbehavior or corruption. Arguing though that the 3 judges named in the petition have genuine grievances, it will be proper for them to seek relief on their own. The proper course should be to commence an action in the courts for a declaration that their transfer or dismissal, as the case may be, is wrong in law. So that the bar exploded this way. I think that the plaintiff's argument on this issue is founded on the fallacy that a Chief Justice's conduct in the administration of the judiciary can never be construed as stated misbehavior or incompetence within the meaning of Article 146 of the Constitution. Other justices of the Superior Court also have administrative responsibilities, such as the supervising High Court judges or judges representing the Judiciary or the General Legal Council. I believe that it will be dangerous and not in the public interest to uphold a proposition in relation to all such judges that the administrative acts cannot ever be the substance of a charge of stated misbehavior within the meaning of 1261. As far as the Chief Justice is concerned, I think it is reasonable to link his conduct of his administrative responsibilities with his position as Justice of all the Superior Courts. Justices of all the Superior Courts are required to adhere by certain judicial ethics, which can be infringed by the conduct of a Chief Justice in the performance of administrative acts. It is therefore unacceptable to exclude a priori all administrative acts of the Chief Justice from scrutiny as possible evidence of stated misbehavior in his capacity as Justice of the Superior Courts. So finally, he had this to say. Moreover, the fact that it is the President who establishes the committee under Article 146 to investigate all allegations that the Chief Justice has been guilty of, such as malfeasance of his administrative responsibilities, as to bring him within the meaning of stated misbehavior under 1461, does not necessarily imply executive interference in the affairs of the judiciary. I accordingly find merit in the counter-arguments of the second defendant set on. So clearly, when the argument is, they are making the argument as though the Chief Justice...
You said you only read and be
yes, the Chief Justice is decouplable from his role as a Justice of the Superior Court.
Okay, and so Dennis, the final comment in a minute that you are going to make it on the back of this question by Kofi. He's asking a question. If the petitioner's relief was for the removal of Gertrude Tokono as a Justice of the Superior Court, what would have been the procedure? If that relief were to have been granted, could she have remained CJ on grounds of constitutional procedural variations? If it was to remove her as a judge and she got removed, would she stay as a Chief Justice?
So you see, you have to be a Superior Court judge before you can be a Chief Justice. I did that in logic in Legon. It's very simple. You cannot be a Chief Justice if you are not a Superior Court judge. But you can be a Supreme Court judge without being a Chief Justice.
That one, I don't even know if it's a fact. No. The President cannot appoint the Chief Justice from outside.
I hear you can be appointed from practice. I hear you can be appointed from a lawyer. But the argument still says. The argument still means that you don't have to be.
But automatically you become a judge.
I'm only helping you.
It's okay. Yes.
Don't help me. I am saying that you have to be a Supreme Court judge or come from somewhere before you can be a Chief Justice.
Therefore.
But you can be a judge, a Supreme Court judge, without being a Chief Justice. So that answer is quite clear. The point we are making is that the framers of the law are clear. They are saying that if you want to remove a judge of the Superior Court, this is the process. If you want to remove a Chief Justice, this is the process. Now, this is where the difference is. There is a clear distinction between the composition of the committee that removes a Chief Justice and the composition of the committee that removes a judge of the Superior Court, and it makes a difference.
Which is just to avoid conflict.
It is not just. There is a reason why if I go to the High Court and a judge rules against me, I go to the Appeal Court. There is even a reason why even at the Superior Court, they can rule against me in a matter, But I will appeal, they will bring one more judge and I'll win. So there is a big difference. It is not just.
You are confused.
It is not just. I am not. There's a big difference.
The
you see, when you look at, don't do this. Don't do this. Don't do this.
No.
When you look at the composition, when you look at the composition of the committees that remove a CJ and a judge is different. The president must appoint certain people. I think for the Chief Justice, the president must have 2 Supreme Court judges and 3 non-judges. For the judge of the Supreme Court, please. But when it comes to the removal of the judge of the Superior Court, the Supreme Court judges must be 3. Do you know what it means? What it means is that you give me the opportunity to go and face the committee that has a responsibility to now remove me as a judge. Because I can be a judge without being a Chief Justice.
Interesting.
I have been removed as a Chief Justice, but I come to you. And I'm telling you that in spite of this established case against me, it doesn't incapacitate me from playing my duties or playing my role as a judge. Because the issues based on which I'm being removed as a Chief Justice were pure administrative issues. They were pure administrative issues that came about simply because I was a Chief Justice and not because I had a challenge in the application of the law as a judge.
Thank you. Yes, Clara. Clara, let Clara end with us.
Yes.
So this is where, after Clara, the show is over. We're unable to move to the Imani Paul's report about dissipating goodwill for the NDC.
It's gone. It's 2%.
There's
level 2%.
Yes.
You have done the analysis.
Yes. What specifically do you want me to address?
Whether you have anything else to say about the removal process.
No, for the removal process, no, I don't have anything to say. Like I said, the procedure is pretty simple. And once the person is occupying the role as CJ, I mean, it's just common sense. You have to, whatever accusation you make against them, you have to use the procedure provided for CJ. So I won't split heads. I don't have any other views.
So,
on that.
like Sophia Akuffo said in one of her interviews, this is de minimis.
Yes.
The law does not.
Yes, de minimis non plures lex. Yes.
Oh, the CJ has, formidable lawyers herself.
No, for me, I like what the CJ is doing. For my person, I like what the CJ is doing. I like anybody who fights for their rights. And that's what the CJ is doing.
Okay.
So whichever way she believes in it, I would applaud and respect the CJ for going all out. One, because I respect people who stand up for themselves. And then 2, because it also helps us to build our democracy. For being in court, I am in with the Chief Justice on that one. I support her being in court. Okay.
Kingsley said, whichever way you are removed as a Superior Court judge, period. He says that Dennis is deconstructing the Constitution wrongly. The Chief Justice was first a Superior Court judge before a CJ. The procedure to remove her as a CJ is different from Superior Court judge. Theo Champion's explanation is superior. He has explained it properly. So thanks to Theo Champion. And then
we ayan sama horo timo koso chana no so mamna se ojembe da sene so bade ndia dumbi edumi enia yensan hyem na yenso kwason ko sokra